Number 760, Michael Vignera, petitioner, versus New York. Mr. Earle.
Mr. Chief Justice, may it please the Court. This is another confession case arising out of a conviction of first-degree robbery after a trial to a judge and a jury in Brooklyn, New York. The petitioner, Michael Vignera, was sentenced to 30 to 60 years. His conviction was affirmed without opinion in the appellate courts of New York. Briefly, the facts are these. Sometime during the morning of October 14, 1960, Vignera was arrested in Manhattan after having been singled out by a Confederate. The Confederate had been arrested earlier that same morning while attempting to use a stolen credit card registered in the name of one Harry Edelman. Vignera was first taken to Manhattan Police Station and then transferred to another Manhattan police station for questioning. At the second police station later that same morning, he was identified as the man who had robbed a Brooklyn dress shop a few days before. Identification was made by the victim, the same Harry Edelman, and an eyewitness. Then, under police questioning, Vignera admitted having committed the holdup by means of a toy gun, having obtained $93. Sometime thereafter, at about 3 p.m., he was formally arrested. Later that day, he was taken to a Brooklyn police station for detention. At the Brooklyn police station at about 11 p.m., Vignera's deposition was taken by an assistant district attorney and a hearing reporter, and that recorded confession was introduced to the subsequent trial. It amplified the earlier admissions given to the police officer, included such additional details as the time of the day of the robbery, the fact that Vignera was operating alone, the weapon was concealed, number of persons in the dress shop, lack of pre-planning, and the like. The next day, on the way to court, Vignera was again questioned about the weapon. Apparently his story didn't jibe with that of the victim, and he finally admitted that, in fact, a knife rather than a toy gun had been used. And it is conceded, although the record admittedly is silent, it is conceded that at no time was Vignera ever advised of his right to counsel or to silence. For example, the confession, which purports to be a verbatim transcript, has no recital of any kind as to a warning. It was not the practice in New York to give such a warning at the time. I think it's entirely fair to assume that no such warning was given.
When you say that he was never advised of his right to counsel, aren't you, A, begging the question, and B, giving up a good deal of your position? Because one of the questions here is, does he have a right to counsel?
Well, you asked that yesterday, Mr. Justice Stewart, and I want to make it perfectly clear that my position is crystal clear, that he had a right to counsel the moment the state proceeded against him. And the moment when that moment arose, it was at no earlier, or no later rather, than 3 p.m. on the day the police formally arrested him. As a matter of fact, in the court...
You had the right to counsel in the Gideon against Wainwright case?
Absolutely.
A constitutional right to counsel.
Gideon decided that question.
Well, then I think you lose your case, period, because then it was the duty of the state to provide him one.
Not necessarily.
Why not he asked for one?
I don't agree with that, Mr. Justice.
That's what Gideon holds.
Gideon holds that he had the right to counsel.
He had to affirmatively waive it, then.
He has to affirmatively waive it. That's absolutely correct. And he has to begin to waive it by the police making a showing of waiver. The burden is on them to show waiver. But in Escobedo, the court said in its footnote that the right to silence and the right to counsel can be waived. And I accept that. That's the majority of the court. Now, the beginning, I would think, the Constitution doesn't require a warning.
I misspoke. Because
the police, I would suggest this is a remedy to the police. If they have some other remedy, fine. But I would think the beginning would be to warn him of his rights in a very meaningful way, perhaps to record the warning.
Well, isn't the beginning, if you're right, then the beginning is just to provide him a lawyer without warning him or telling him anything else.
Well, that would certainly be an easy way of handling it, but...
It's the only way to satisfy the Gideon rule, isn't it?
No, I don't think it is, Your Honor, again, because of the waiver point. They obviously don't want to assign counsel. The police aren't very well equipped to do it, and they have to give them. They will want undoubtedly to try and get them to waive. Now, if they can do that, I say the Constitution, at least at this point, history doesn't require any more. Although I should add that even if they get a waiver, we have to look rather suspiciously of that kind of a waiver, and it wouldn't entitle the police to hold him in custody indefinitely even after such a waiver. It would be a very limited waiver concept, in the sense of a principle comparable to McNabb and Mallory.
Well, would he have to have a counsel if the police, when they arrested him and detained him, took him in charge, just left him alone and asked him no questions?
No, I don't think.
And let him answer. If he said anything voluntarily, that might be one thing. But if they interrogate him, then unless they interrogate him, he wouldn't need a lawyer.
Well, I'm not so sure about even spontaneous statements once the accusatory stage has been reached, Mr. Justice Black. But I do think that if they locked him up and didn't get near him, didn't use him in a discovery sense as a device to participate in his own subsequent conviction, that he would not have to, a lawyer would not have to come to the police station. Because he has to be prejudiced.
He wouldn't need one, would he?
He might, it would probably be very helpful for him so the lawyer could investigate the case along with the police. But in terms of criticalness that you were talking about a moment ago, he has to be prejudiced at the trial. I don't think it would be critical if nothing has happened. Once they start a process that tends to undermine the Fifth Amendment privilege, it is certainly very critical. And I might say that it's been perfectly clear from what General Taylor said yesterday and some of the other arguments that many of the briefs want you to overrule Escobedo, and their attacks, I think, have been very thinly veiled. I'm going to assume that Escobedo represents the law in this court and in this country.
May I?
Which part do they want to have overruled?
Which part of Escobedo?
I think the majority opinion in its entirety, Your Honor.
The holding or the rhetoric?
Well, if you mean by rhetoric, Mr. Justice Stewart, the several references to the Sixth Amendment, I think they're part of the holding. And when the Solicitor General's brief talks only about the Fifth Amendment, I'm only perplexed. I read what I read, and that reference is in there several times, that there is a right to counsel. And the critical stage can occur prior to arraignment and prior to trial.
Mr. Earle, may I ask your help on precisely that point? Let's suppose that this conversation, which, as I remember, it took place in a police car going from point A to point B, in which Vignera said something or other about the weapon. Let's suppose that had been the first act here before any other, the first statement that Vignera made. In short, assume with me that the police picked up Vignera, and then in the police car going to the station, Vignera said that he did it, that he did the hold-up, and he used a knife. Now, would that be inadmissible because of the absence of a warning or the absence of counsel?
Mr. Justice Ford, as you asked a question like that yesterday, I think the question of does focus and arrest come at the same time? I think that in the hypothetical you gave, the statement might well be admissible. Certainly, a laying on of hands is an arrest, but the probable cause requirements, and there was, I think, probable cause satisfied here because he'd been singled out by a Confederate. The probable cause requirements are probably not the same as the determination that the state has charged him and has begun its proceeding against him. I can conceive of examples, for example, when the police have to make on-the-spot judgments, take in 4 or 5 people who may have been involved in the crime, 4 of them exculpate themselves and they're sent home, and the 5th is proceeded against. Maybe he's picked out of the lineup by the eyewitness. At that point, it becomes clear that the accusatory proceeding has begun, and then he'll have to be, then the police are going to have to show waiver. Any statement after that, in the absence of waiver or in the absence of counsel, will be inadmissible.
Well, how do you apply that to my example? I'm really soliciting your help.
I think your example.
Because I think this is the problem, as I think Mr. Justice Douglas's questions indicated, that this is a real problem of defining with such precision as is possible and advisable the point at which the warning has to be given or counsel provided or both. So that, here you have a man who is taken into custody by the police. It's an arrest in the sense that he cannot thereafter leave. The police have him. And then on his way to the police station in the police car, he makes a statement that is in effect an admission. The question is, would that be admissible, in your opinion, if it were made prior to the warning having been given and prior to the offer or appointment of counsel or the waiver thereof?
In the absence of any form of coercion, Mr. Justice Fortas, I think it would be admissible. I'd like to give you a different hypothetical, though, to show you that I think, in my judgment, this thing would vary. For example, even before arrest, the accusatory stage might come into being if in a situation, government agents had a man under surveillance and saw him commit some very suspect acts and then laid their hands on him. I think there it would be perfectly clear they were proceeding against him, and you'd move the state even farther back. But in a more typical situation, as in Vignera, I think the accusatory stage doesn't begin until sometime after hands have been laid on and he comes to the police station. Here it may have been after he was identified.
Forgive me, I don't want to take excessive amount of your time, but is this what you're saying, that when the point of time comes where it appears that the police have enough information to satisfy themselves that the fellow really did the act, that then the right to counsel or to warning attaches and not before? Is that what you're saying?
I think that is correct, although we don't have to look into the minds of the police necessarily. We'll be able to determine that, and they should be able to determine it. And if they're in doubt, I think some people will say, well, how do the policemen know this? If they're in doubt, give the warning, push it up, err on the side of the warning. But that's why I don't see why it should pose so much of a problem. I think the FBI agents who've been giving this warning for so many years probably err on that side.
What should this warning contain, in your view?
Well,
talk about a warning. What should this warning be?
The chief of police in the District of Columbia last August promulgated a warning, which I understand is now being given by all police agents police officials in the district. It goes something like this. You have been placed under arrest. You are not required to say anything to us at any time or to answer any questions. Anything you say may be used as evidence in court. You may call a lawyer or a relative or a friend. Your lawyer may be present here and you may talk with him. If you cannot obtain a lawyer, one may be appointed for you when you first go to court. Now, I might have a little bit of a quibble about that third point, because it suggests a little bit that you might not be able to get a lawyer now if
more
you
than
want
a little
one.
bit of a quibble on the basis of what you've told us so far.
Excuse me?
Much more than a little bit of a quibble, I should think, on the basis of what you've argued so far, that he has an absolute right to a lawyer to be appointed for him right at that point. That's what I understood you to say. Unless he waives it.
Unless he waives it.
Yes.
And then the question might come up, well, what do the police do when the fellow says, well, thanks, I'd like a lawyer, as a matter of fact, now that you mention it.
Yes.
But I don't happen to have any money. They have a very simple choice. They can give him 10 cents and the phone number of the Legal Aid Society, the public defender. And if that bothers them, if they're unwilling or unable to do that, they have another alternative. Just stop interrogating him. Mm-hmm. That alternative is never mentioned by anyone.
Well, I don't quite yet understand the answer to the question I asked you. What should the warning contain? Not what you read us, obviously.
Well, what I read, I'm satisfied with.
As far as it goes, but that's not enough, is it?
I think it's enough if it's made to an adult who is not a moron or who has his faculties. I think that's probably enough.
Well, then he's not entitled to a lawyer until the trial begins.
No, that's not correct.
Well, would you read again what the warning was?
Well, let me do this for you. I didn't write this warning.
No, but you now say it's sufficient, as I understand.
I would be happy with the first two sections of it. One is, you've been placed under arrest. You are not required to say anything to us at any time or to answer any questions. Anything you say may be used as evidence in court. 2, you may call a lawyer or a relative or a friend. Your lawyer may be present here and you may talk with him. Now, they've got a 3 that I just wouldn't add.
Right. In other words, you'd stop right there and you'd say that was sufficient.
That's right.
Well, then what happens? What if the fellow says nothing at all?
Absolutely nothing?
Well, they give him the warning and he nods his head, yes.
Well,
I hear you. And then what happens?
It takes a conscious relinquishment of a known right for him to waive his rights, those 2 basic rights you've been talking about, Mr. Justice White.
I understand. I thought that's what you would say. Now, what happens then? The fellow says, he just nods his head, just looks at him.
Well, if we can believe that he nodded his head, it's possible that he waived. I'd be very reluctant to come to that conclusion on that hypothetical.
Well, what besides giving the warning and the failure to request counsel?
I think if the warning is reported, if he writes down in his own handwriting that I have been warned, I understand that I have a right to a lawyer now to talk to him right this minute if I want to, or I have a right to say nothing if I want to, I understand that, but I would like to go ahead and cooperate with the police, sign Michael Vignera, that would be enough.
So why would that warning, that's just barely the first stage.
Well, that's what the police have to say.
Sure, the police have to say that, but if they want to rely on a waiver at any time, which is the only ground that you would accept for a lawyer not being present, is a written waiver, isn't it?
Oh, I think that's right. I think it should definitely be recorded in some way.
There should be a written waiver of counsel.
Absolutely, and it shouldn't be something that he's conned into giving.
Just the giving of the warning is only a minor first step.
Well, no, Mr. Justice Stewart asked for me to read the kind of warning that would satisfy me. Those are the words that I think make some sense. But it's got to be made meaningful to him, and he's got to acquiesce in it.
Well, what if he doesn't waive and he says, "I do want counsel," and the state says, "Fine, here's a dime and there's a legal aid number," and the fellow calls him, he talks to the lawyer, and he comes back and sits down, and you ask him some questions, and he answers them.
Without his lawyer being present, for example?
Yeah.
Well, I take it that would be a decision made by his lawyer. And lawyers can waive rights for their clients.
Well, is that a waiver in your book?
It's
well, what is it? Is it the waiver of the right to consult counsel, or the waiver of the right to have counsel present?
I think it's a waiver of a right to have a lawyer in all the sense that is always meant. So and the lawyer can make a determination whether he wants to be present or not. Lawyers have waived many rights, including cases that have come to this court, not filing on the 30th day and notice of appeal and the like. And if he makes his decision to throw him to the wall.
Yeah, but my question was really going to what you think the scope of the right is. You think the scope of the right is to have counsel present, and that you must find not only the waiver of the right to consult counsel, but the right to have counsel present.
I think that is right, Mr. Justice White.
Well, I just wanted to know what your position was.
Just, for example, right, but I want to elaborate on it, if I might. In a deposition in a civil case, for example, customarily the plaintiff and defendant would have counsel present. But I could certainly conceive of one lawyer deciding not to be present, and his client, through him, would thereby waive that right. Well, it seems the only way we can distinguish this case from Escobedo is the fact that Vignera did not make a request. And what we've been talking about with respect to waiver, I think, governs that. Obviously, it wasn't the request that makes the right attach. The right attaches when the state proceeds criminally against the individual. The significance of the request, I think, in Escobedo was that was an objective piece of evidence to show that that stage had been reached there. Actually, it's even clearer in Vignera that in this case, that at least by 3 p.m. the stage was clearly reached. There's an independent ground to support reversal in this case, and that is the fact that Vignera was detained for an unnecessary period of time. I think that's true both under state law and as a matter of common reasoning. He was, even after the accusatory stage had clearly reached, the police had formally charged him, he was not then arraigned. He was not arraigned for nearly another 18 hours. And I think the point you raised yesterday, Mr. Justice Black, doesn't detention, and I would add especially prolonged detention, doesn't that cut down on the Fifth Amendment privilege? Doesn't it whittle it away? Doesn't it undermine it necessarily? And I would say that it certainly does. As I said earlier, I hope the principle the court adopts is one which combines warning with a rule at least analogous to the guidelines set down by McNabb and Mallory. So even if there is a waiver, the man can't be detained indefinitely. Of course, in my case, there wasn't even a waiver. And there was this.
How can there be a waiver if these are absolute constitutional rights of the importance that you emphasize? How can anybody waive them without the consent of counsel, without the advice of counsel? Doesn't he have a lawyer? Doesn't he need a lawyer before he can waive them?
Well,
right.
They're entitled to waive them in other situations. It's true in court. When they want to plead guilty, for example, the judge will, and decline assignment of counsel, the judge will typically interrogate him at some length as he realizes the significance of his act. And that is a lot more visible a situation and more conducive to our being receptive to the idea of waiver than a waiver in a police station. I agree that that's probably the worst place you can... the party alleging waiver has control over the party alleged to have waived.
Right. So if you're right, it would seem to follow, I should think, that he needs a lawyer before he can waive his right to a lawyer. He needs the advice of counsel.
I wouldn't be terribly unhappy with having lawyers in the police station, Mr. Justice Stewart. I'll be very clear.
Well, I should think it would follow naturally from your
Well, it doesn't follow naturally because the majority of the court in Escobedo said these rights can be waived. I think we do have to recognize some of the realities of law enforcement. They do have to investigate. They do have the hurly-burly of crimes that are being committed by the minute. And they do have to operate out of a police station. I think when we're dealing with adults, if we use tape recordings, if the police go to great lengths and indeed do it with a professional spirit, with a spirit not of antagonism, with a spirit recognizing that they are inevitably in an adversary situation, and the man they're dealing with has rights, and they want to protect their conviction. They want to make sure they can get a conviction. They don't throw it out by some careless error. And I might say this is a good example, this case, of where the constable certainly didn't blunder. Here at midnight, after all these hours of detention, a member of the bar marches in with his stenographer. I mean, it certainly was deliberate. There's much talk in the briefs, in the SG's brief, about the exigencies of the moment. The exigencies of the moment weren't bothering the assistant district attorney. He was just operating his convenience at 11 p.m.
Is there a claim in this case that the admission was coerced?
In no sense, Mr. Justice Harlan. I don't think it was coerced at all. But I like to say, Mr. Justice White asked yesterday a question about compelling someone to give up his Fifth Amendment right, his privilege. And I think there's a substantial difference between that and coercing a confession. I mean, it wasn't until 1964 that the Fifth Amendment privilege applied to the states. And so the court inevitably, all through until the 60s really, state convictions were overturned only by looking to the generality of the totality of circumstances under the Due Process Clause. Now we have specific constitutional guarantees that are applied in root and branch to the states, both the Fifth and the Sixth Amendment rights. And it's true that the word compel is used in the Fifth Amendment with respect to the privilege, but it's quite different to say that the privilege is cut down or impaired by detention, and that a man's will has been so overborne that a confession has been forced from him. And I must say, I was a little perplexed to read the Solicitor General's brief when they talk about the principle they would have the court adopt is basically a Bram principle relating to the Fifth Amendment privilege. And then they support that with citations to coerced confession cases, talking about having one's will overborne and going back to the totality of circumstances. The trouble with totality of circumstances in this field, and that would get us back to Betts and Brady, Mr. Justice Fortas, that you mentioned yesterday. Betts against Brady was not a right to counsel decision. It was a due process decision. I hate to sound too cynical, but if we go back to totality of circumstances, that means that this court will sit all by itself, as it has so many years, to overturn the few confession cases that it can take, necessarily by the bulk of its work. And the lower courts won't do their job. We need some specific guidelines, as is this Escobedo, to help them along the way. Well, you can't decide every case in advance, Mr. Justice White. I don't think it's that hard to tell, for lawyers certainly, or for their trained agents, to know when they've made up their minds to charge someone. The English seem to have no trouble with it. In fact, the New York police for years have had this fiction of saying, I arrested him at such and such a time, that time being long after he was taken into custody. What they meant was I'd made up my mind at that point to charge him. So all I'm saying is that you make up your mind, so give him a warning. I can't understand what all the fuss and feathers is about.
Charge, so far as charge by the government goes, it's usually a rather formal thing. It's an indictment or it's an arraignment on a charge. The various procedures in the states vary, but that's an identifiable event because it's a formal event. That's true. As Judge Friendly said, we're talking about something here that is short of any defined legal stages, and I agree that that is so.
I'm interested in your statement, Justice Harlan, that there's did you say absolutely no coercion in this case?
Well, there's no claim of coercion, Your Honor. I certainly...
I suppose it's, what do you mean by coercion?
Well,
you mean completely free from all compulsion. Compel means compulsion. Do you mean completely free from any governmental compulsion?
No, it was not free of that, certainly.
Why wasn't it?
Because he was in official custody and questions were being asked of him by officialdom. And questions suggest the right to receive answers.
What you mean then by was not coerced is what?
I mean that it was not coerced in the context of the coerced confession cases that this court has decided until now.
We are now talking about the Constitution.
That's correct.
As well as the confession cases.
That's right.
What about the compulsion here? Can you say, or do you think that the Fifth Amendment is an amendment to protection means man must not be under compulsion to give a statement?
I think it does mean that. That's right.
Well, does that mean free from all compulsion? Are we to construe the Constitution, like you said in Boyd, against the United States? giving all liberality to what it means and what was intended to protect?
I think we should. I think you should.
Well, if that is true, can it be said that this man gave the confession free from all compulsion?
He certainly didn't in the Fifth Amendment sense.
Well, that's the sense we're talking about.
That's right, Your Honor. I was merely making a distinction between that and the coercion cases.
You're making it.
Yes, under the Due Process Clause.
That's right, and it didn't refer to compulsion. That was the idea of looking at all the circumstances.
That's right.
To see if it's too offensive to the court.
And it looked.
And the constitutional provision is that they shall not be compelled to give evidence against themselves.
That's correct, but those cases also look to the subjective mind and volition of the accused. And I say that that's irrelevant in the Fifth Amendment sense. That's right. I think a volunteer statement is out if it comes after the accusatory stage. No question about it. On the other hand,
you're getting pretty close to the rule that prevails by statute in India, where no statement of any kind by a person in custody to the police is admissible in evidence.
In the absence of waiver, we would be very close to that, except that prior to the accusatory stage, the police would be entitled to screen, put people in lineups, presumably, and even ask questions on the way down to the police station. They do have the duty to investigate crime, and it's certainly a duty we have to recognize.
It seems to me that in this case, while the two merged to a certain extent, there's been almost complete emphasis on the right to counsel.
Well, I don't mean to imply that.
Rather than emphasis on the fact that the man is not to be, the government is not to take confession from him by compulsion, whatever that compulsion is.
Mr. Justice Black, I think that detention, particularly prolonged in a police station, is inherently compulsive. And there's no question but the core right that lawyer should be able to protect if he gets the chance is a privilege against self-incrimination. And that was the chance that never arose here.
We've been there 15 minutes, and they say, you are under arrest, we think you committed a murder, and we are taking you down, and we're going to interrogate you. Do you think he's under any compulsion when they ask him the question?
I think as a matter of logic, he is.
Well, logic, I'm talking about fact, reality.
As an advocate, I'm constrained to be bound by the opinions of this court, Mr. Justice Black, and no decision has gone that far.
We are reviewing a whole series of cases with reference to the extent, coverage, and protection of the Fifth Amendment and the amendment which provides the right to counsel. And whatever we've said in the past, there's no reason why we shouldn't discuss, and counsel shouldn't discuss, as I see it, how far they believe the Fifth Amendment's protection actually goes, and not without regard to what we've said in the past.
Well, to answer your question specifically, I think the privilege only comes into play once the accusatory stage has been reached.
Once what?
The accusatory stage has been reached. So 15 minutes might not be enough in a given case, or it might, depending on the facts.
Then you want to get back to Betts versus Brady?
No, I don't. I get back to Escobedo v. Illinois. And I'm perfectly happy with that decision. The reason for that, Mr. Justice Black...
If you're going to determine it each time on the circumstances after a man has been arrested, means that someone has just set free. This court must take him up one by one. And no court in the land can ever know what violates that right not to be compelled to incriminate yourself until it comes to us and we finally decide.
Well, that's the last thing that I want, as I tried to say earlier. I think that this stage is going to come very early.
A little more than we are capable of doing.
It certainly is.
Present capacity to work.
It certainly is. But you see, my problem is this. The police have to investigate crime, and they have to talk to suspects. And I think when they talk to a suspect, his right to silence may very well be impaired. But I don't think that it's critical or that they should be debarred from doing that until they have proceeded against them.
Quite a difference in them meeting a man or asking him if he wants to talk with him somewhere and going and taking him to the police station or taking him in charge and detaining him of his liberty. Quite a difference between voluntary.
There certainly is. And if the court were to hold that in every case the accusatory stage arises once the man is taken into custody, I would say hooray.
Well,
I'd be perfectly happy with it.
I don't like labels, and therefore I don't like accusatory stages. I like to consider what happens. What you're talking about is, as I understand it when you say the accusatory stage, that the government, state or federal, has moved against the man, something like they said in the Magna Carta. It's moved against him. And from that moment on, they're entitled to due process of law, whatever it is.
That's right. He's the defendant. if that's the time it should be, that's certainly fine with me. And as a matter of fact, that really is my point. It's the premise we begin with. Many briefs begin with the premise that there's a need for police questioning. There certainly is that need, but the premise we begin with is that the Constitution recognizes when the man is proceeded against. At that time, the burden shifts to the police.
Mr. Chief Justice. Mr. Siegel. May it please the Court. If the Court will forgive a personal reference, I'd like to say a word or two about myself. I've been a prosecutor now for 26 years. 10 of those years very busily engaged in the trial of cases, and by quick computation, 16 years as the head of the Appeals Bureau in the Kings County District Attorney's Office. But I was a citizen before I became a prosecutor. And I trust that I am still a citizen despite this long record of public service. And it is for this reason that I think some of my colleagues, professionally and officially, have said things and seem to me to have made concessions with which I do not agree. And I think that there has been much too much talk of the police on the one side and the defendant on the other side, and not enough reference to the rights of the community. And if I may, this is the point of view that I want to espouse here this morning. May I say in passing that I have briefed the question of retroactivity. I'm neither a prophet nor a prophet's son, but like one of my ancient ancestors, I'm willing to prophesy that there is at least a possibility of some decision coming out of this argument, of these cases, with which I would perhaps be unhappy. In any event, which might raise the question of retroactivity. I do not argue it because this case has not become finalized within the definition in Linkletter, but I brief it because New York obviously has a great interest in the question of retroactivity. We have thousands of cases, I suppose, where convictions were based in whole or in part on confessions. My very able young...
Do you have, in your own experience, any judgment as to what proportion of the cases, not that confessions are used in, or that not that confessions are important evidence in, but those cases where without the confession you wouldn't have a case?
We tried to do that when these cases were allowed up by the court. And I think it's obvious that we didn't have very much time in which to...
The short of it is that you have no... do you know of any reliable statistics on this?
We don't have, in my judgment, that type of empirical data that Mr. Justice Stewart spoke about, on which the court could put very much reliance. For myself, I base my argument on the importance of confessions on human nature and human experience and human evaluation. It's a principle of conduct that people don't... Of conduct, of human life. That people don't, as a rule, confess crimes which they haven't committed. And it is for this reason that courts have always said that a true, honest, unforced, and uncoerced confession is the highest type of evidence. And what our point here really is that we don't want to be deprived. We don't want to lose the opportunity to get that type of evidence, not for ourselves, not for any prosecutorial record, not for the satisfaction of winning a case, because I hope we are given the benefit of the presumption that we are above that, but for the benefit of the community. And so I would answer you, sir, that if I were fortunate enough to be in the seat of decision, I wouldn't lay too much stress on presently, at least, unavailable data of that type. Mr. Nedrew has tried to get some on behalf of all of the district attorneys, and in his brief he has some statistics. Doesn't go very far. I don't think it really can, because after all, when we try a case, we don't write up and say we got this conviction because of a confession, and it wouldn't have happened if it hadn't been for a confession. Oh, yes, where the confession is the only evidence. Of course, sometimes it happens that the confession is later found to be faulty for one reason or another. It happens either in this court, as witness Lira and Noy, or it happens in the lower court. But there are cases where only the confession is available to the prosecution.
Did you say that there are cases in which confession is later found to be unmerited?
Yes, there have been. The records of this court contain two within my own experience, and there are others where this is so. But I hope there won't be too much importance laid upon this fact, because the impropriety of the confession in these specific cases is only proof of what we all know, that no human institution is perfect, and that we can't expect or require from a prosecutorial system that perfection which is wanting in every other department of human affairs.
Mr. Siegel, I suppose it's at least arguable that prior to Magna Carta and prior to the adoption of our own Bill of Rights, most people who were convicted were guilty. Nevertheless, it has been the wisdom of the ages that some safeguards are necessary. Isn't that so?
Yes, I agree with that.
And I suppose that if one tries to look at this philosophically and morally in terms of the great human adventure towards some kind of truly civilized order, that these great provisions in the Magna Carta and our own Bill of Rights were designed to do two things. One, to eliminate even the unusual case of an unjustified conviction, and two, to lay out a standard for the relationship between the state vis-a-vis the individual. Do you think that observation is justified?
Oh, undoubtedly, sir.
That is to say that basic to this whole problem that we're considering, however one may come out in the terribly difficult, vexatious, tormenting decision as to where lines should be drawn, however one may come out on that, I think that perhaps one has to consider that what we're dealing with here is not just the criminal in society, but it's the problem of the relationship of the state and the individual in the large and total philosophical sense, viewed in light of the history of mankind, part of that history being Magna Carta and the Bill of Rights.
Well, Your Honor, if I may refer to your second desideratum first, there is no question that it is the hallmark of Western civilization. It is the command of this court. It is the command of the Constitution. It is the desire of all proper-thinking people that justice shall prevail according to civilized standards. My point is that the standard Well, let me second dispose of your first disavowal. What you pose, it seems to me, is an ideal that no man shall ever, under any circumstances, be convicted under an improperly procured confession. Now, this is an ideal, and an ideal, by very terms of definition, is unattainable. The only point I make is that because under a standard which I prefer to any set rules, which is what my brilliant young opponent is arguing for, the standard works well and enables courts to perform their true function. And the true function of a court is to find out where the truth lies.
Well, Mr. Siegel, I suppose that even in a extreme communist state, that most people who are convicted of crime are really guilty. But I equally suppose that you would join me in finding it abhorrent if those people were convicted without having counsel and what we consider to be a fair trial. Isn't that right? So, the point upon which I'm asking a comment is that perhaps it is an oversimplification to take a look at this problem solely from the point of view of facilitating the task of putting people in jail if they committed crime. Isn't that right? In other words, doesn't this problem really affect the basic relationship of the individual and the state? And it's really goes beyond the administration of justice, and that's been the history of mankind. If one wanted to say that a 90%, if police get a 90% justifiable result, well, that ought to satisfy anybody. If you want to be pragmatic and practical about this and say, well, police secure the conviction and in 90% of the cases it's all right. Now, it's a very sensible attitude in one point of view, but perhaps it's a point of view that's been rejected.
Well, Your Honor, I hope you won't.
Our history.
I hope you won't believe that I disagree with your larger objectives, the larger social objectives that you pose, when I say that there is an immediate objective also. And the immediate objective is to protect society, because if society isn't protected, if in one degree or another it lapses into anarchy because of criminality, then the opportunity to reach this beautiful ideal is gone.
Well,
and it is the function of the policeman.
I don't think you want to refer to something that is as fundamental as phrase beautiful ideal, but I completely agree with you, and that's the reason that we're sitting here. The problem is to reconcile a good many objectives and values that are not totally consonant, but I am a little troubled, I must say, when I sit here and hear so much reference to this problem as if it were merely a pragmatic problem of convicting people who did it, who did a crime, because there's many more dimensions, I suggest, to the problem than just that simple statement.
The conviction is only a means, let me say, to a larger end. And the larger end is the preservation of the peace and dignity of the Commonwealth for the good of everybody who resides in that Commonwealth.
And certain religious and moral values.
Well, this is inherent in our social structure. And I suppose the problem that these cases pose is, well, I have to start again. There's an old aphorism. It's a principle of law, as a matter of fact, that it is better that 100 guilty men go free than that one innocent man be convicted. And this aphorism expresses a point of view with which everybody is in agreement. But it isn't a mathematical equation. There isn't an exact 100-to-1 ratio. It's an expression of a philosophy. And the problem that's before this court, it seems to me, is just how to keep the balance between the ultimate necessities of a civilized, peaceful society and the constitutional rights of a specific defendant.
Don't you think that Bill of Rights had something to do with making that balance?
Yes.
Not any doubt, is there, that they said that no person should be convicted on evidence he'd been compelled to give. Why do we have to get into a discussion of society, beauties of the ideal civilization, when that's the issue before us?
Because the Bill of Rights only says that he shall not be compelled. But the word compelled is not self-defining. What compelled means comes from this bench. Now, we, for many, many years, were told by Your Honor's predecessors, and I would say by a great majority of Your Honor's predecessors, that compelled meant that you couldn't make a man talk by the exercise of process.
By the what?
The exercise of process. You couldn't subpoena him into a court and sub poena under pain of punishment make him talk. Now, nobody disagrees with that. And I take it that we are beginning to live.
But then here the main argument we have is whether without summoning him to come into court and talk without process,
All right.
he can be seized and detained
Yes.
and interrogated
Yes.
while he is in detention.
Now, Escobedo says...
whether that's any compulsion.
Escobedo says, as I understand it, Escobedo says that when he asks for a lawyer, or a lawyer asks for him, to make him, it's a lapsus lingua, to take from him a statement after the rejection of these requests is compulsion. If I get Your Honor's point of view, it is that you don't have to wait till he's in the accusatorial stage.
I don't know what that is. I don't know what that is any more than the fact that a citizen
may I venture a
has been
definition?
seized by authorities and kept with them against his will.
May I venture a definition? The accusatorial stage is when the police have a prima facie case, and it has become their duty, a magistrate or a commissioner being available, to bring him to that functionary for arraignment. This is a true accusatorial stage. But I have a question. If he is entitled, and Escobedo says he's entitled not to be questioned at that point, why isn't he entitled to not to be questioned at the very point when he's under police restraint so as to stop the probability or even the possibility that by questioning the police will put him in the accusatorial stage? To me, there's a lack of logic in making this distinction between the investigatory process on the one hand and the accusatory stage on the other hand, because you don't reach, so far as the participation of the arrestee is concerned, you don't reach the accusatory stage until you first had the investigatory stage. And if it is wrong...
Do we have the investigatory stage in this country? I didn't know that we could arrest people for investigation.
Well, I am using the terminology of Escobedo, which makes the distinction. You can ask people to come in and talk. No question about that, and you don't have to invite them in with a lawyer.
But on the question of the accusatory stage, wouldn't you say that the accusatory stage had commenced when a man found himself locked up in jail?
No.
Why? Somebody has accused him, or they wouldn't have put him in jail.
Well, somebody may suspect him, but they haven't accused him.
Have they a
Accusation is a technical
Have they the right?
term.
Have they the right to put him in jail because they suspect him?
It's an old common law right, as I understand it, to stop a person and detain him for a reasonable period of time for for discussion and investigation. I don't think this has ever been disputed.
Has this court ever said you could put men in jail and hold them there during the investigation of the police unless the police arrest him for probable cause?
It's like many other things, Your Honor. It's relative. I think it's been recognized. There's a whole model code on the right to detain that's in preparation. New York has passed
Where is that model code?
Sir?
Is that in the Constitution?
No, sir. No, sir, but Your Honor...
I had an idea that the model code, so far as protecting people's rights against government was concerned, basically speaking, had to be found in the Constitution.
I agree with you, Your Honor, but may I say this?
And that we long ago got over the idea that this country tried to adopt every old principle of the common law.
I agree with that, but may I also say that what we're talking about in every one of these cases is a question of definition and what the Constitution means. Now, I know that the Constitution has been differently defined in different eras, and I know also that we are in a period of the history of this court where the changes in definition are rather accelerated, let me put it that way. But case by case, the question always is, does man live alone, or is he a member of this community? And doesn't the community have some rights under the Constitution? Now, it may be that what the community has...
Nobody could agree with you on that more than I do.
Now, then we always reach a question of the accommodation of these rights. The community must not, for its own benefit, take away any of the rights of the individual. But the individual's rights must not be defined beyond the point where they are necessary to protect him from oppression by the community. Would
it be wrong to substitute for that the idea that the individual rights should not be taken away from him any further than the Constitution properly defined requires, instead of balancing?
Mr. Justice Black, it is with the greatest respect to you that I say this is a matter of semantics. Because because the Constitution does not define, the Bill of Rights does not define what a man's rights in any given circumstance are. We have to come here.
Not be compelled to be a witness against himself.
We've always had to come here to find out what compulsion meant. We didn't know. I've always found Mr. Justice Frankfurter to be not only a great stylist, but a great student of the Constitution. And it is for this reason...
Well, we agree on that.
Yes, I have no doubt. I have no doubt that despite your classic divergences of opinion in Adamson against California and others cases, you and Mr. Justice Frankfurter had the highest regard for each other. But it seems to me that the question in this case is not whether you should have, as a practical matter, an equivalent of the McNabb-Mallory rule for the states, and not just exactly when the right to counsel applies, although I think I've given you an illustration which might almost drive us all to the point where he needs counsel the minute he stopped and said, "Will you please come down to the station? We want to question you." The question is and ought to remain what it has always been and what Mr. Justice Frankfurter said about it in Columbia. The ultimate test remains that which has been the only clearly established test in Anglo-American courts for 200 years, the test of voluntariness. Is the confession the product of an essentially free and unconstrained choice by its maker? If it is, if he has will to confess, it may be used against him. If it is not, if his will has been overborne and his capacity for self-determination critically impaired, the use of his confession offends due process. Now, Mr. Justice Frankfurt wasn't talking about a mythical man. He wasn't talking about an average man.
He wasn't talking about the Fifth Amendment.
No.
I think he was, sir, with great
Did he
deference
say
to
so?
you.
Did he say so?
No, it wasn't involved there.
He said due process, didn't he?
Yes. But the question here is whether the due process clause, the Fifth Amendment and the Sixth Amendment are going to be brought in under the 14th Amendment, and even independently there still remains a question.
Mr. Siegel,
Yes, sir.
may I ask you this question in view of your long experience? There have been references many times, some made by members of this court, to the effect that if lawyers were brought in at the early stage, pre-trial stage, they would always advise the person in custody not to say anything. Now, there are instances, however, where lawyers who represent persons under arrest or in custody tell their clients that they ought to plead guilty. Is that, in your experience, does that occur quite frequently, or do most of the people who plead guilty, not represented by counsel?
In New York, we have this right. We've had this right to counsel long before it became a pressing question. Betts against Brady, or Powell against Alabama, or Gideon, or any of them.
So that the guilty pleas are entered after consultation with counsel.
Always.
And are guilty pleas rather frequent in your experience?
Oh, yes. We couldn't dispose of the volume of our business if we didn't have 85 and 90% pleas of guilty.
So that, let's say, 85 or 90% of the instances, there are defendants or persons under arrest, and their lawyers do tell them to plead guilty.
But of course, Mr. Justice Fortas, this is after the lawyer has learned of the strength of the people's case, and I don't think this has any relationship whatever to the problem of the lawyer talking to the defendant at the time of arrest or accusatorial stage.
That's exactly
Because in my experience, and I have dealt with hundreds of lawyers who specialize in the criminal practice, it is a rara avis indeed who will ever, if he comes into the police station, say to his client, now you go and cooperate with the district attorney. Every one of them. And of course there are exceptions, but they only prove and test the rule. Every one of them will say to his client, and how he'll say it will depend only on whether he's a purist or he uses slang or not. But actually, he'll say to him either button your lip, or don't talk, or shut up, or anything like that. But
Well,
he'll dry up this fountain of possible evidence.
Yes, but presently, and our experience up to this point, I suppose, is based on those people who do have lawyers at that stage.
Which stage, Your Honor?
At the investigatorial or accusatorial stage.
And may I ask what Your Honor's experience has been?
Well, no,
I understood you say your experience.
No, I didn't say that.
I'm sorry.
I said that our experience, the experience of our legal process, has been with limited groups of persons and limited numbers of persons who have counsel at that early stage. Isn't that right? That is to say that most people don't have counsel at that stage.
That's right. That's relatively rare. Very rare.
So that I suppose there's not a coincidence between the number of people who plead guilty and the number of people who have counsel at the investigatorial or accusatorial stage.
I know, Your Honor, they may plead guilty because their conscience bothers them. They may plead guilty because they've decided that for one reason or another, including perhaps a moral reason, they're better off. They may plead guilty because a district attorney offers them a quid pro quo. There are many reasons why a man pleads guilty. But certainly, it is not a fact that they have been put in the position of pleading guilty only because when they were brought in the police station, they had no counsel. You must give...
I understand that. I wasn't making that point.
You must give...
I wasn't making that point at all. What I was doing really was trying to ask for the benefit of your experience with respect to this statement that so many people are now accepting without any thought, and that is to say that lawyers would practically always advise their client not to say anything.
I believe
now, now, it may be that has to be broken down into two parts. One is what the lawyer's advice to the client is before the lawyer's looked into the case. The other is what is the lawyer's advice to the client after the lawyer's looked into the case. And to my mind, there is a question as to whether if a lawyer, as he frequently does now, on the basis of what you said, tells a client pleads guilty, must we assume? Therefore, how do we reconcile that fact with the statement that the lawyer would always tell the client to button his lip, as you put it?
I don't think there's any contradiction at all, because the lawyer advises his client to plead guilty after he's talked to the district attorney. And a fair district attorney will say to him, now look, this is what I have. I have this witness who testified to so-and-so. I have a statement from your client. Do you want to see it? I've let people see statements. And as a matter of fact, we now have in New York a statutory provision, Section 813F of our code, that if the district attorney intends to offer a confession in evidence on the trial, he must give reasonable notice to the defendant before the trial, and the defendant has the right to a pre-trial hearing as to the issue of voluntary.
Well, would it cripple law? Would it handicap law, materially handicap law enforcement if the person who was under arrest started talking to the police only after his counsel had talked to the state's attorney?
Based on...
I'm asking for your observation.
Based on my experience, Your Honor.
Yes.
While, of course, there will always be exceptions, it is my honest belief that a warning to a prospective defendant in the police station or bringing a lawyer in, the manifold difficulties, practical difficulties of those of that are obvious, that this will dry up practically the whole stream of confession. And now, it's been put this way: if you want to equalize the defendant and the police, maybe you ought to do it. But if you want to preserve the rights of an individual, I think this court should be careful as to how it defines his rights so as not to prejudice the total rights of the total community.
Thank you, Mr. Siegel.